since you've been in the oil and gas industry forever, you would have insight into this. But I think there's also a question of just the psychology of it. Because if you look at Rex Tillerson, for example, nominated for Secretary of State, ExxonMobil CEO. Well, a couple years ago, he joined a lawsuit because he didn't want fracking going on near his house. Kelcy Warren, CEO of Dakota Access, Trans-Pecos. Oh, he's building wind and solar near his house. He's also building one of the biggest wind farms in the Caribbean. So it seems that these are intelligent individuals personally. They might know both the risks of fracking or devaluating their property and object, or they might know, oh, wind, solar, that's the next economic boom. So for them personally, and these are just two examples, I'm sure there's more, they know the dangers, they know it devaluates their property, they also know the opportunity and other alternative ends. In terms of the oil folks, I'm not asking for names, does it just seem to be a human element of, greed and hypocrisy in this? Because it seems that way to me.
There's something that's inherent in people that I can go clear back to Jefferson's Declaration of Independence. It's not in my backyard. And that's what's going on. That's the problem. What's going on in Trans-Pecos is in nobody else's backyard. How that's going to get changed, I have no idea. I'm going to make a run at it this time. I have a proposed amendment to the condemnation statute sitting with one of the state senators and waiting to find out if he'll run with it. And if he does, I'm going to broaden the inquiry at this point. But you got to try. And my sincere hope is that I get a forum to where I can get some of the people that you probably met in the Big Bend to come down here and talk to the members of the committee or whoever. Here's what's happening, and here's what it's done to me, and you need to change it. That's all I know to do. You're not going to beat this any other way, because until the laws change, pipelines will keep doing what they're going to do. Now, part of what's going on out there is when the pipeline gets a permit, like Trans-Pecos, you're probably going to have a whole lot of instances where they are abusing that privilege and tearing up land they shouldn't be tearing up, or Lord knows what. I'm aware of one ranch. It had a Indian mound, which was an archaeological site, certified, probably 10,000 years old. And they asked the pipeline to, don't mess with it, go somewhere else. And he said, no, we're not changing our direction. They bulldozed it down and put a porta potty on top of it. And we have a picture of that. So they're abusing the privilege. And the same thing you've seen Mr. Warren say, I'm not moving that North Dakota pipeline. I am not moving it one single inch. And why? Nobody can make him. The Railroad Commission, a district judge, the Supreme Court of Texas cannot move a pipeline. It has to be moved before the permit is granted. And there's no process for that.
You've mentioned a lot of laws. Can you just concretely, what is the main law that needs to be changed here?
It's in the property code. There is a section, chapter 21 in the property code, which is has the basic format for condemnation process. The second thing that needs to be strengthened, at least as far as gas utilities are concerned, which are different than common carriers, there needs to be a set of standards made that they have to comply with in order to be qualified as a gas utility to have the power of eminent domain. that needs to be done before they get the permit. Common carrier, Supreme Court of Texas dumped on a company called Denbury Pipeline, transporting carbon dioxide from Mississippi and going to bring it into Texas. And they were claiming to be a common carrier. They were a private line coming across Mississippi and Louisiana until they got to the Texas border, and some miraculous vision came to them as they crossed the Sabine River, and they became a common carrier. Supreme Court shot them down because all they had was a piece of paper. There was a T4 permit. It says, I'm a common carrier, therefore I have the power of eminent domain. The court bumped them. They sent it back to the trial court. It's back now in the hands of the Supreme Court the second time, and it was argued in this spring, early summer. No decision yet. It's got some problems, and I think the court's got to make a pretty tough decision. But there are a number of statutory standards as far as a common carrier. There's some ambiguity in that statute that probably could be cleaned up, but there are at least some guidelines there for the court to look at and say you are or you are not a common carrier. We don't have that in the gas utilities. And that's why Warren went that way, because it's very hard to beat. Under the framework in the statute, it's very hard to disqualify a common carrier. But in this instance, I think they've done it to themselves by getting that federal permit to export gas. If I can just get somebody to listen. Trying.
And one more. If you had Kelcy Warren next to you, drinking eggnog in a few days, what would be your message to him?
Nicole asked me that same question, and I think I answered what was going on then. He had sicked the dogs on the people in North Dakota, and I said, call off the dogs. I would ask him, because he's a very, very powerful personality, very strong personality, has a lot of political influence. I would ask him to sit down and give serious consideration to helping us change the law to balance out the situation between him having the power of eminent domain and the rights of persons to protect their property. It's got to be balanced out. We're not going to stop pipelines, but we need to get the process to where the landowner is more comfortable and has input and says, no, this is not right. I don't want you to put it here. I know I can't stop you, but put it over here. And here's why. With an agency that has the authority to change the route. We've got that kind of law in the books in Texas now. For instance, if a big electric company goes to the Public Utility Commission and they want to put in a long line transmission line, these big powers, they have a huge public hearing with input from anybody that's on the proposed route to come in and say, don't put that tower here, put it over here, or not at all. And here's why. There is the public input that allows these issues to be fought out before an agency who has the authority to put the line someplace else. And that's what's got to happen. So we got that kind of stuff on the books now, and hopefully if we can get a form for changing the property code, we can look to that and say, legislature, you've already done that in different areas. Why not a pipeline? Give them, there's one statute that nobody looks at that gives the Railroad Commission authority over a coal pipeline. Now, we don't have one in the state, so it's never been used. But that particular statute, which declares a coal pipeline to be a common carrier, requires the Railroad Commission to have public hearings in the field along the line to let people come in and talk. It's never been used because we don't have a coal pipeline in this state. But what I want is that same process in the common carrier, and I would like for it to be put into the gas utility statutes. That gives the public a chance to sit down and say, here's my problem. I know what's going on. Nothing's a surprise. I know I'm not going to stop it, but I have concerns about this or this or this or this. That is what has to happen. Now, that's very idealistic. Politically, I don't have any idea. But you got to start somewhere. And if we get a foot in the door this time, 2 or 3 sessions down the road, maybe we'll win this road. But somebody got to pick up the flag and run with it. So I hope I can leave that legacy.